Good afternoon, and thank you for joining us. This has been it's been an exciting 24 hours in New York employment law, as many of you may have heard that the New York State Department of Labor, in consultation with the Division of Human Rights, issued its final guidance on sexual harassment prevention and training yesterday. And as many of you are likely aware, that gives you approximately 1 week to come into compliance with the requirement relative to having a harassment policy. Thankfully, one of the pieces of information that came out of that guidance was that the training requirement, which goes into effect, or pardon me, required the training be completed by December 31st of this year, has now been pushed back to October 9th of 2019. But we'll talk a little bit more about that. Just needless to say, it's been an exciting 24 hours, and I'm sure the next week will be, as well, as we try to get as many employers as we can into compliance with these new requirements. Our agenda, we're going to start by talking about what's legally required in terms of the policies and the training. There are certainly some resources that are available, and I'll share some hyperlinks with you at the end of the presentation. There is what's legally required is now a baseline. What the state of New York has done is basically required all employers to do something that we have been advising employers to do for some period of time, which is to adopt a policy. But now you are out of compliance with what it will be known as Labor Law 201G if you do not have a policy on sexual harassment and provide that to your new employees as well as your existing employees. So we're going to talk about those policies, we're going to talk about training, and then we're going to talk about best practices, because while there is a requirement that you have a policy and that you conduct training, the models that have been put out by the Department of Labor do not go quite as far as we would really like them to in order to protect the organization from liability. And I think it's important that we understand that there are two potential sources of liability here. One of those sources is non-compliance with Labor Law 201G, and the other, greater threat, frankly, is a liability for failing to maintain a harassment-free work environment, which could result in litigation and legal exposure far exceeding that exposure related to not complying with Labor Law 201G. So let's start with what's legally required. You may be surprised to learn that some of these requirements already went into effect, and this is one of those requirements. Effective April 12th of this year, New York employers are now exposed to potential liability for sexual harassment of non-employees who are performing or providing services in the workplace pursuant to a contract. So, for example, in the credit union context or in the association context, this would not mean that a member could sue you for being harassed by one of your employees. But if you have a contractor on site, or you have a consultant, independent contractor on site, and they're performing work and they are exposed to harassment while they are providing those services in your workplace, effective April 12th of this year, they can sue you. That's important because I know many of you may not even had a policy, but frankly, a best practice is not only that you have a policy, but that you share that policy with these non-employees who could potentially sue you for being harassed in your workplace. At a minimum, they need to be told who it is that they can report harassment to. So, and that is something I can candidly tell you most employers, regardless of size, were not doing. They had policies, but they were not advising these non-employees of the complaint procedure. But it's important to do so, because otherwise one of these non-employees might sue you under this newly amended provision of the New York Human Rights Law. Frankly, you should just assume that you could be held liable if in fact harassment is occurring in your workplace. So let's talk about the sexual harassment prevention policy. By October 9th, and that is next Tuesday, and this date was not pushed back. There's a common misunderstanding circling already that the training deadline was pushed back to October 9th, but in addition, the deadline for adopting and sharing a policy has also been pushed back to 2019, and that's not the case. The guidance is very clear that by October 9th, all New York employers are required to adopt and distribute a written sexual harassment prevention policy. And this policy can either basically the model policy that has been published by the New York State Department of Labor, and we'll talk about that, or it can be your own policy as long as that policy equals or exceeds the minimum standards provided in that policy. As I mentioned, the final guidance was issued on October 1st, and we'll talk a little bit more about that model policy and where it falls a little bit short of protecting the organization. In terms of distribution of the policy, the state of New York says that you do not need to get a signed acknowledgement. I say you do. While the law does not require, this law does not require that you have a signed acknowledgement. In the course of defending employment harassment cases, or pardon me, sexual or other forms of harassment cases, one of the key issues really is our ability to establish that the employee knew of a complaint procedure and failed to utilize it. And the way we do that is to present a signed acknowledgement of receipt of that policy. So even though the state of New York says you don't need a signed acknowledgement, I would urge you to obtain one. You may distribute it electronically. That is the policy. If workers can access it on a computer provided by the employer during working time and are also able to print a copy. Also, as I said, very important, even if you make it available electronically, that you obtain an acknowledgement of receipt. So we're able to establish that, in fact, the employee received it. So that's the requirement, and generally speaking on the preceding slide, but there is a detail that is offered in the statute that establish minimum requirements. And these minimum requirements are that the policy must include a prohibition of sexual harassment, which is pretty standard and would be included in most policies anyhow. Information concerning federal and state statutory provisions concerning sexual harassment, and you must also note there may be local laws. This is not something that we would generally include in a harassment policy, primarily because the goal of the harassment policy is to be user-friendly and to acknowledge, or pardon me, inform employees how they go about addressing harassment, as opposed to informing employees how they go about suing you. But this is a requirement and not something that you can exclude. Frankly, the language that is contained in the model policy is as good as any to satisfy this obligation. And I would suggest that employers would be treading in dangerous waters if, in fact, they decided to omit this language, even though the language is very legalistic and goes on for numerous paragraphs. You also need to include a standard complaint form, and this is italicized because this is not something I would normally include in a harassment policy. And one of the reasons for that is a lot of times employees are reluctant to raise a concern because they're afraid of getting somebody in trouble, or they're afraid of making too big of a deal out of something. And for that reason, you know, when I draft policies, I don't even use the word complaint. I use the word report, because too often employees, supervisors, managers get too hung up on the word complaint. Now we're required to have a written complaint form, and the Department of Labor has created a model form that is not awful. It's not precisely how I would draft it, and certainly we are tinkering with that form, tailoring it to specific clients' needs. But you are going to be required to have a complaint form. According to the guidance issued yesterday, it need not actually be a part of the policy. You don't need to incorporate it, but at a minimum, you have to let employees know where they can find that complaint form, which could potentially be on the intranet. I would not suggest that you indicate that the complaint form is available from supervisors, because, for example, if the employee is being harassed by a supervisor, they're certainly not going to feel comfortable going to that supervisor to obtain a copy of the complaint form. But we will need a complaint form as part of this policy. You also need to include a procedure for timely and confidential investigation of complaints, and this is very new and very different language, and ensure due process for all parties. Obviously, we do generally comply with basic standards of fairness and objectivity in doing an investigation, but due process for the alleged wrongdoer is generally not a primary concern, and certainly not something that we guarantee in policies. However, in accordance with this new requirement, we do have to actually address that, ensure that due process is provided, and also outline what our procedure is going to be for investigations. Again, this is not something we would generally do, because the procedure for investigations varies from situation to situation. One of the concerns about the model policy is that it goes into a lot of detail and suggests that this is what's going to be done in almost all circumstances, and that's going to raise employee expectations. And it could also have a chilling effect on complaints from employees who don't want to, quote, make a big deal out of the conduct that they are addressing. Further minimum requirements, the policy must include information regarding the employee's rights and all available forms for adjudicating harassment complaints administratively and judicially. This goes to that language I mentioned earlier. This bullet is satisfied by that same language that goes on for about 3 paragraphs. Well, actually, it's more than that. I combine them into about 3 paragraphs, but it's many paragraphs at the end of the model policy that addresses the employee right to file a complaint with the Equal Employment Opportunity Commission and the New York State Division of Human Rights and to file a lawsuit and potential rights under local laws as well. It also needs to include a statement that sexual harassment is employee misconduct and address the sanctions that may be imposed for those who engage in it. This is standard fare that would be included in any policy that we draft. We clearly want to make sure employees know that they face disciplinary action for engaging in harassment. And lastly, a statement that retaliation is unlawful, which is very important because retaliation, frankly, outnumbers sexual harassment complaints before the EEOC and represents a very significant threat. So addressing retaliation, making clear that it is unlawful, is very important in your harassment policy. So talking about that model sexual harassment policy, just touching on some key elements. It states that sexual harassment includes harassment on the basis of sex, sexual orientation, self-identified or perceived sex, gender expression, gender identity, and the status of being transgender. This is important because that is not something that we would generally go into detail in a sexual harassment policy or a harassment policy generally. And so that's important to include. It needs to make clear that non-employees are protected from sexual harassment. As we mentioned, that went into effect in April, so it's important to note that as part of the policy. And that harassment can occur outside the physical workplace, which is frankly a good addition and something that we include in our harassment policies, because a lot of times employees are under the misimpression that if they're not on company time or on company property, that couldn't form the basis for a harassment complaint, and in fact, it can. Some more key elements: encourage employees to report harassment, but require managers and supervisors to report. Candidly, this is another area where the model policy differs significantly than a policy I would draft. I require everybody that's aware of harassment to report it, whether they're an employee, a supervisor, a manager. I don't quite understand why they decided to make this distinction, but I would advise that we require anybody who is aware of harassment to report it. As I mentioned, we have to include a written form and a written complaint form, and there is a sample provided. It indicates that employees are encouraged to use the complaint form when reporting harassment, but they can be made verbally as well. What's interesting then is it goes further and says, if the complaint is verbal, encourage the reporting individual to complete a complaint form and complete the complaint form for the individual if the individual refuses. Again, that's not something that I would ordinarily do because it's unnecessarily proceduralistic and technical, and we don't really need to do that. And so I would generally not go further than to say you're encouraged but not required to complete the complaint form. That allows employees to raise concerns without fear that this minor concern is going to be blown up into something bigger. I imagine that a lot of employees reading this language, supervisors or managers or employers that read this language, if an employee refused to Okay, so it should be prompt and thorough and completed in as timely manner as possible. The policy should detail the steps that are going to be followed in every investigation, including documenting the investigation, the findings. So again, it requires a little more detail in a policy than we would normally include. At the conclusion of the investigation, complainant will be informed of the right to file a complaint or charge. Again, I would never put that in a policy. I would never, after investigating an allegation of harassment, go and tell somebody, now here's just so you know, you can still sue us if you'd like. And that's not something I would generally include in a policy. I would, however, include that information in the policy itself, but I wouldn't require that at the conclusion of an investigation, we're going to remind employees of that. And then a description of external remedies, including filing a complaint with the Division of Human Rights, the EEOC, or contacting local police if appropriate. And that is, again, the language that I referenced that is contained in the model that it would be sent to include, even though I would not ordinarily include it in a policy. So now let's move on to the anti-harassment requirements with regard to training. Every employer is going to be required to provide annual sexual harassment prevention training to all employees. Now, mind you, we would normally recommend that just like your policy address all forms of harassment, not just sexual harassment, and by that I mean race, national origin, disability, age, etc., your harassment training should also cover all forms of harassment, recognizing that more than 55% of all of the complaints filed with the EEOC allege harassment on a basis other than sex. This is sort of a big gaping hole if we're going to be training employees relative to sexual harassment but not touch on other forms of harassment. Again, you can utilize the model sexual harassment prevention training that has been created by the New York State Department of Labor. They have a PowerPoint that they will be or that they have made available on their website, or you can establish a training program that, again, equals or exceeds the minimum standards provided by the model training. The deadline, again, as I mentioned, has been pushed back to October 9th, and then once per year after that. So you only have to complete it once between now and October 9th. The question arose, what if we do training routinely and let's say we did it earlier this year? Do we have to do another full-blown training? And the answer from the Division of Human Rights and Department of Labor is no. You merely need to supplement it by addressing any points required in the training that weren't covered in the training you provided previously. So you'd need to supplement it. Personally, I think that would be a bit of a train wreck that you're going to try to just a train on specific issues, but in a vacuum without the context of the full presentation. You know, I think if you just did training in July of this year, then why don't you hold off and do it in July of next year? And now you have plenty of time to do that. I mean, there is some benefit to doing, to pushing this off into later in the year. And then new employees, under the old guidance, it said it needs to be within 30 days. They need to be trained. Now it says they need to be trained as soon as possible. But the policy should be provided prior to commencing work, and actually makes good sense. I tend to recommend that employers provide new employees with a copy of this policy as part of onboarding, as part of orientation, or when you're presenting all of those various documents to the employee to get them to sign a copy of the policy as well. They do address the issue of what are you supposed to do if, in fact, an employee fails to complete the training after you make it available. Well, they can't quite get themselves to use the word discipline. The Department of Labor says the employer may take appropriate administrative remedies to ensure compliance, which I read to mean that you can discipline an employee for refusing to participate in this training and thereby preventing you from becoming compliant. Now, the minimum requirements, keep in mind, there's a difference between the model policy or training and the minimum requirements. The minimum requirements you have to adhere to. The model you do not. So the minimum requirements include that it be interactive, and I'll talk more about that in a minute. It needs to include an explanation of sexual harassment, which it should, examples of conduct that constitute unlawful sexual harassment, which is also a good idea, information concerning federal and state statutory provisions concerning sexual harassment and the remedies available to victims of sexual harassment, as well as the employee's rights to redress and all available forms for adjudicating complaints. I would never in a million years address this as part of training because it's so legalistic, and you're frankly going to lose the audience as part of this training. But the Department of Labor says, the New York State Legislature says we now have to include this. So we're going to have to include that in the training. As I said, it needs to be interactive. It also needs to include information on conduct by supervisors and any additional responsibilities for such supervisors. This is a best practice anyhow. We always want to make sure that supervisors are aware that they are held to a higher standard. So I generally recommend that supervisors and employees be trained separately. That's not what's envisioned by the model training. But ideally, we would train supervisors and then we would train employees. Or at a minimum, if we're small and need to do one training session, you would do a group of everyone up front, then you dismiss the non-supervisory employees and continue training the supervisory employees. In terms of interactive and the definition, in the FAQ document that the department issued yesterday, they altered their approach to what constitutes interactive training by noting that it can be online so long as it is interactive, and Examples of employee participation include if the training's web-based, having questions at the end of a section and the employee must select the right answer, or the employee may have an option to submit a question online and receive an answer immediately or in a timely manner. So if it's web-based, I think the challenge is that the employee has to be permitted to ask a question in addition to responding to questions. And certainly most interactive trainings, web-based trainings, are set up to have a post-test. But does the employee have the ability to submit a question and receive an answer even immediately or in a timely manner? And that could be a bit of a challenge. You're gonna have to make sure that if you used a web-based training or an online training mechanism, that it has that capacity. Examples of employee participation also include an in-person or live training, which is always the best training, and see what the EEOC has recommended. The presenter asks the employee questions or give them time throughout the presentation to ask questions. If it's web-based or invite a feedback survey for employees to turn in after they've completed the training. So again, get some feedback of employee participation. The earlier draft include as many that has been removed from the final guidance. So these are examples of employee participation, and they end by citing that watching a training video or reading a document only with no feedback mechanism or interaction would not be considered inactive. So I do think it's important that you have that interactivity because it is legally required. And what does that look like? An opportunity for the employee to ask questions, and certainly an opportunity for you to ask questions of the employee so as to ensure that they are comprehending the information that is being presented. In terms of the model, and again, this is the model, not the minimum requirements, but the model provides training and requires that the training be provided in language that is spoken by employees. I think that this is something that will be required by the Department of Labor, so that if you have an employee that speaks a foreign language, they need to receive the training in that language. You need to address who can be the target of harassment, who can perpetrate the harassment, and both of those could be employees or non-employees, particularly in associations and credit unions. Sometimes the individual engaging in the harassing behavior is a non-employee. So we have to be concerned not only do you be concerned with the potential that a non-employee could be a victim, but a non-employee could also be a harasser, and we need to be prepared to address that. Where sexual harassment can occur, and also sex stereotyping. In addition, the training should discuss reporting expectations, which is very important because it protects us from a legal liability perspective. Describe the complaint procedure and include the names and contact information with which employees should file their complaints. This is interesting because not something we would normally include in training, in part because those names and contact information can change. Nonetheless, given the fact that this is in the model, I am recommending that that be included in the training. Detail, and actually bear one thing in mind here. So they have a model training and they have a PowerPoint, but that is not tailored to fit your specific organization. And similarly, if you go out and obtain sort of an off-the-shelf webinar type training, that's not going to. The best practices are what is going to protect you from potential legal liability for harassment, as opposed to merely not complying with Labor Law 201G. And so let's start with a news bulletin, and that is that Harvey Weinstein did not invent sexual harassment. Although Me Too movement has certainly been the driving force behind many of these legal developments, including the most recent relative to Labor Law 201G's requirements. The fact is that sexual harassment has been a problem in workplaces for some period of time. And so one of the big problems or challenges that existed at Fox News and in the Weinstein companies is not so much that there wasn't a policy and that there isn't there wasn't training. Certainly there was policies and training at Fox News and the Weinstein companies. What the problem was is that there was a culture of complicity. So you're not going to solve a harassment problem merely by adopting a policy or conducting training. Instead, you're going to have to make sure your culture is such that employees know that this will not be tolerated. Harassment is very common. Sexual harassment is the single most common form of harassment, with 46% of all harassment charges alleging sexual harassment. However, more than 50% of all charges alleging harassment before the EEOC are on a basis other than sex. 54% of all of the complaints allege harassment on a basis other than sex, and yet the model policy and the model training don't address other forms of harassment, merely sexual harassment. So we're talking about not just sexual harassment, but harassment based on race and color and national origin and religion, sex, or pardon me, age, physical or mental disability, genetic information, predisposition or carrier status, marital or familial status, military status, domestic violence victim status, or any other protected bases, including a known association or relationship with someone who's in a protected class. So sexual harassment is, again, 46% of all the complaints, but the threat is much larger than that. We do a study of employment litigation every 10 years in upstate New York, and found that between 2001 and 2012, the last time we completed this study, there was one upstate New York employer sued for employment discrimination every business day. And when you look at what that translates into in terms of potential liability, because I said we're not just concerned about the liability for not having a policy and training, but also the liability for sexual harassment and exposing employees to sexual harassment. And the Northern District of New York is pretty much north of Westchester, the Canadian border, west to and including Syracuse, and then the Western District of New York is Rochester and Buffalo. In the Northern District of New York, you're looking at almost $500,000 in a jury award, with another $100,000 of attorney's fees on top of it. So these are significant, particularly for small organizations. And that's why I think it's so important that we not lose sight that we don't want to simply check the box by having the policy and doing the training that's required by New York state law, but also to understand that we need to think more broadly than that, and to all forms of harassment, not just sexual harassment. So how do we create or prevent harassment? You've got to create a culture that won't tolerate it, let alone condone it. So how do we do this? You've got to adopt appropriate policies, which include harassment, fraternization, and technology use. Harassment, we've discussed. Fraternization is at a minimum requiring that supervisors not become involved with subordinates, or at least require disclosure of any such relationships. Technology use, because so much of the harassment that we're seeing occurs online and via electronic devices. Very important that we address that in the technology use policy. You've got to conduct effective training. You need to encourage employees to raise concerns or to whistleblow. You've got to allocate sufficient resources and time, and particularly with small organizations, I know that's a challenge. But unfortunately, I think the short timeline we've been given to come into compliance with 201G is going to result in employers sort of doing what needs to be done, doing the bare minimum, doing what's cheap, and that may down the road be something that they end up regretting. But certainly we've been able to buy some time on the training front, and that's helpful. And then lastly, the C-suite must walk the walk. The bigger the commitment from the C-suite, the more likely we're going to have employees who understand that our culture is one that will not tolerate this behavior. So best practices would also include responding appropriately when you receive a complaint, or when you become aware of inappropriate conduct. You got to take appropriate action, and it needs to be swift and firm. So we need to understand that the way you maintain a workplace free of harassment is that you don't wait until somebody's crying in your office or who's filed a complaint with the Division of Human Rights. When you see the inappropriate email that never should have been sent, you take action to address it immediately. And so we've had cases with employers that had executive vice presidents who had worked for the employer for 3 years. They sent an inappropriate email, and they were terminated as a result of sending that inappropriate email. Even though that one email would not create a hostile work environment, that's enough to cause the employer to send a message by saying this is not okay. So you might be asking, should we adopt the model policy? I mean, it's certainly easy, right? It's right there. You just have to plug in your name, but there's serious deficiencies. It's improved. The initial version referenced the term zero tolerance, which we strongly recommend employers not use, because zero tolerance causes employees to believe that if they raise a concern, the alleged wrongdoer is going to be terminated. And a lot of times victims don't want that to happen. It's also suggests that there's a one-size-fits-all approach, that when you receive a complaint, zero tolerance will result. And that causes employees to believe that the employee that engaged in the wrongful conduct is going to be fired. And if they're not fired, they're unhappy. So thankfully, zero tolerance was taken out. The policy is long and frankly, from my perspective, excessively legalistic. It creates a one-size-fits-all approach to investigations by saying, we're going to investigate everything, and here are the steps that we're going to take, when in fact, you may not always take all those steps because it may not be necessary. It emphasizes, like I referenced, written complaints, and a lot of times employees don't want to make written complaints. So yeah, I think you need to balance the fact that we're legally required to provide a complaint form, but that we're not going to push employees into completing it. It also requires the employer to notify the employee who complained of their right to file an external complaint, and that's not something that I would generally include in a policy, as I mentioned. So should you use the model training? Well, the model training is deficient in several respects too, as it focuses on sexual harassment almost exclusively, just like the model policy. It tracks that model policy, and as such, there's very specific in the procedures and steps that are going to be taken in response to a complaint. And ironically, it includes case studies that perpetuate sexist stereotypes. 5 out of the 6 case studies, I believe, involve a man harassing a woman, but not any other of the novel forms of harassment which we've seen on the rise, which include same-sex sexual harassment, harassment where a woman is harassing a man. So it's a little bit ironic, but the case studies are not case studies that I would have chosen. So what is an employer to do? First, you need to draft and or revise your harassment policy to comply with the minimum standards. I mean, generally what we're telling clients is if you already had a compliant policy relative to harassment generally, it's best that we tinker with it to make the additions that we have to make in order to meet the minimum standards without throwing out the best practices that we already had boiled into the complaint procedure previously. Recommend that you have it reviewed by counsel, and obviously this needs to be done by October 9th because next Tuesday is that deadline. And then you need to develop a plan to train all of your employees. Thankfully, we've bought some time in terms of when that needs to be completed. It doesn't need to be done until October 9th. Of next year, but I wouldn't put it off, and I would develop a mechanism for training our employees. And lastly, on the PDF of this, I included some hyperlinks to resources, including the draft model policy, the minimum standards for the policy, the draft. Pardon me, they're no longer draft. I prepared this before the presentation. Before the final came out, but it's now the final model policy, the final model training, the minimum standards for training, and the FAQs. And so those hyperlinks will get you to the New York State website that has that information. So with that, I've made it through the material, have about 5 minutes to answer any questions you might have. I don't see any in the queue, but if you have any that you would like to submit, I'd be happy to respond.